Hi guys, we're going to talk about legal and ethical guidelines for safe practice. And this is going to be chapter 2 in your ATI book. And I'm just going to get started here. So we must first define some ethical concepts. So when we think about ethics, this is the study of philosophical beliefs about what is considered right or wrong in a society. Because ethics are philosophical and involve values and morals, there is frequently no clear-cut, simple resolution to an ethical dilemma. When we talk about bioethics, we can define it as used in relation to ethical dilemmas surrounding healthcare. And then ethical dilemma are conflicts between two or more course of action, each with favorable and unfavorable consequences. So nurses are often confronted with ethical dilemmas regarding patient care, and unfortunately, there is a favorable and an unfavorable consequence with each dilemma. 6 principles of bioethics, which again should be review for you, are autonomy, beneficence, non-maleficence, justice, fidelity, and veracity. And you can see all of those defined there. I'm not going to go through those because we've already discussed those in a previous chapter and also in a previous course. So what are some evolving ethical issues in psychiatric care? The first one we can think of is pharmacogenetic testing. This is used to help identify which antidepressant to use on a specific patient based on DNA profile, with the goal of eliminating that trial and error and improve recovery time. The literature and the FDA do not support this use due to lack of clinical evidence. So what are some of the mental health laws that we can think about? So a couple of types of admissions that I want to talk about. The treatment of mental illness occurs all throughout the community in varying levels of inpatient and outpatient treatment settings, really depending on the severity of the client's manifestation. There are 2 primary types of admission for inpatient hospitalization or residential treatment, and that is voluntary and involuntary. Emergency admissions are often considered a subtype of involuntary admission for the purpose of evaluating a mental health crisis. What we see most often with mental health is voluntary and involuntary. So voluntary is sought by the patient or the guardian. The patient is considered competent. They have a right to request and obtain release, but before being released, they must be reevaluated at that time, and the provider can initiate an involuntary admission if they feel that that might be necessary. When we think about involuntary, that means that the patient enters the mental health facility against their will for an indefinite period of time. Typically 2 medical professionals that collaborate and they agree that the admission or a family member can document why the patient may be at harm for themselves or others. Legal counsel may be involved if the patient chooses. If the patient is not released by a judge, then involuntary admission does proceed. When we talk about due process in involuntary commitment, there's a couple of forms that we can think about. The first one is writ of habeas corpus, which means a formal written order to free the person. Patients who believe they are being held without just cause can file a petition for a writ of habeas corpus, which means a formal written order to free them. The paperwork is the procedural mechanism used to challenge unlawful detention by the government. Least restrictive alternative doctrine is mandates that care providers take the least drastic action to achieve a specific purpose. So for example, if you can treat someone safely for depression, On an outpatient basis, hospitalization would be too restrictive and unnecessarily disruptive. So in the case, however, assisted outpatient treatment could be legally mandated in certain cases. So as we look at discharge procedures, the one I want to think about is the release against medical advice. So an AMA discharge may present an ethical dilemma for clinicians. On the one hand, patient's autonomy and the right to refuse treatment support the patient's wishes for discharge. On the other hand, the clinician's beneficence would support benefiting and promoting good, which includes protecting the patient. Discharge, again, always starts with admission. So a conditional release usually requires outpatient treatment for a specified period of time to determine if the patient is going to be compliant with the medication regimen. Can they meet their basic needs, and are they able to reintegrate into society safely? Unconditional release is termination of the patient from the facility. No regulations of either party. So they can just get back out into society. As far as patients' rights, they do have the right to treatment, which means that the environment needs to be humane and the staff must be qualified and the care is individualized for the patient. They also have the right to refuse treatment. They can withhold or withdraw consent at any time. This is where medication can come into play. Even though a patient is involuntarily admitted, that does not mean that they are forced to take medications. Some criteria may alter that if the patient is in an emergency situation. They do have the right to informed consent, meaning a physician provides information regarding a procedure before it's done. The risks, the benefits, and any alternative treatments are reviewed. In saying all of this, informed consent is given to those that are able to make the decision and are competent. If a patient is deemed incompetent by the legal system, then it will go to the guardian. That might be a spouse, an adult child, a grandchild parent, adult sibling, nephews, nieces, whoever may be their guardian. If none of these are available, then the court will appoint a volunteer guardian. When we think about implied consent, an example might be a patient is approached with a medication in hand and the patient indicates a willingness to receive the medication. Implied consent has occurred. Capacity is a person's ability to make an informed decision. The right regarding psychiatric advance directives. This is a document that the patient can clarify their treatment preferences. This document is prepared when the patient is well and can identify their wishes regarding treatment decisions. When we think about rights regarding restraint and seclusion, there is a history of restraints and seclusion that is marked with abuse, overuse, and punishment. And we don't want to promote this. And by law, we aren't allowed to. We are reducing their movement of the patient. We also have to think about chemical restraints. So medication that is not being used to treat their condition. Chemical interventions are typically not as restrictive as physical restraints, but we are still inhibiting their ability to think clearly. When we talk about seclusion, this is confining a patient to a room against their will, leaving them alone and preventing them from leaving. This is usually done if patients are endangering themselves or others. Now, seclusion can be requested by the patient and is really considered just a time out, but the door is left open and they can come and go as they please. And obviously the last right is to confidentiality, right? We don't want to talk about any of our patients in any hospital settings or with anybody else that isn't on a need-to-know basis. So as we continue talking about that confidentiality piece, the healthcare provider is prohibited to disclose privileged information without the patient's consent. Confidentiality is an ethical responsibility of healthcare professionals that prohibits that disclosure. There is some exceptions to the rule. One is duty to warn and protect any third parties, usually including assessing and predicting the patient's danger of violence toward another person, or identifying the specific person being threatened. We will have to take appropriate action to protect those identified victims. So if your patient comes to you and says, I want to kill the patient next door, right, that's a third party, we need to make sure that we are protecting that third party potential victim. The other exception to the rule is statutes for reporting child and older adult abuse. So the laws are relevant to our psychiatric nursing. So when we think about those, we think about tort law. Tort is any wrongful act, intentional or accidental, that could result in an injury to others. Intentional tort is willful or intentional acts that violate another person's rights or property. We can also think about assault and battery, right? Assault is that verbal, I am going to hit you, versus battery, actually performing the hitting. Unintentional torts are negligence and malpractice, and again, those are those unintended acts against another that produce injury or harm. So 5 elements to prove negligence is duty, breach of duty, cause in fact, proximate cause, and damages. I'm going to focus on cause in fact, which is sometimes known as actual cause, and may be evaluated by asking the question, if it were not for what this nurse did or failed to do, would this injury have occurred? Proximate cause or legal cause is determined by whether the event was foreseeable. So if it was an unforeseeable event, that's different. But if it was foreseeable, then we may need to look at that proximate cause. So standards for nursing care, we can think about State Board of Nursing. These are our governmental agencies that regulate nursing practice. Professional associations elevate the practice of its members by setting standards of excellence. Institutional policies and procedures define criteria for care, and these criteria can be used during legal proceedings to prove that a nurse met or failed to meet them. A weakness of this method is that the hospital's policy may be substandard. And then custom as a standard of care can be used as evidence of a standard of care. In the absence of a written policy on the use of restraints, testimony might be offered regarding the customary use of restraint in emergency situations where the patient poses a threat of harm to self or others. So what do I mean by acting on questionable practice? We've talked a lot about negligence, or some about negligence, irresponsibility, or impairment, right? We have the duty to intervene and the duty to report. The reporting process is there to present what actually happened. Was there harm that actually happened? And we want to make sure we document clearly and accurately. Supervisors typically will intervene. If they're unavailable, you must intervene to protect that patient. Documentation is always a usefulness in determining how accurate and completely care was done. It portrays the patient's behavioral status at the time it was written. So making sure it's accurate, it's complete, it's very subjective. Patients actually have the right to review the record, but the record does belong to the institution. Medical records and quality improvement is just retrospective record reviews are done frequently. You'll probably start hearing about those as you get into your nursing career. Medical records can also be used as evidence. So making sure that you're recording everything very subjective, not putting your own advice or thoughts into it. if there's patient damages or suffering, if there's injuries such as abuse cases, any disability cases, any injuries, all of that stuff that could be used as evidence. Some of the guidelines for electronic documentation are listed here. Again, it manages data and communication, reduces errors, and facilitates decision making. Federal privacy laws on access. The court can't assume it if it's not documented, it didn't happen. So you'll hear us faculty say that quite often, right? If you don't document it, it didn't happen. It doesn't matter how many times you say, but I did do it. If you didn't write it down, it didn't happen. So a little bit more about restraints and seclusion. The use of chemical or physical restraints should be regarded as the last resort for our client's safety and must be based on clear and specific guidelines. Physical restraints is a manual method, mechanical device, or physical material or equipment that reduces movement or the ability of the client to move their arms, legs, or bodies. Chemical restraints are a substance or drug used to restrict movement or manage client's behavior. Seclusion is that involuntary confinement that we've talked quite a bit about. The goal for nursing and mental health care is effective treatment and management of the milieu. The milieu is that environment, right? It includes minimizing potentially dangerous behaviors. While the client is restrained or secluded, the registered nurse must frequently assess the client for any changes in status. It is required for the provider to place an order. Protocols are focused on client safety with expectations is for continuous direct observation and monitoring based on federal, state, and facility guidelines. Safety and well-being with specific attention to cardiac and respiratory status. We're also going to check skin integrity, hydration, risk for injury, and sensory stimulation. Environmental considerations, making sure they're free of hazards and have adequate lighting, ventilation, and proper room temperature. We're going to observe the client's response. So when we're observing those clients' responses, we want to make sure that we are support and reassurance of their safety, ongoing assessment of circulation and skin integrity, care of basic needs and hydration, food and elimination, range of motion, medical interventions, including those medications that they may need to be taking, and then just evaluating of the responses of those interventions. If the client's status deteriorates, the physician must be notified immediately and the restraints may need to be removed. So release from restraints or seclusion is really based on the client's response and ongoing assessment. Restraints can be removed on the recommendation of trained registered nurses, physician assistants, physicians, and licensed independent practitioners. When we release the restraints or seclusion, it's really going to depend on the patient's behavior that's been demonstrated and identified for the reason of putting them in the restraints, right? If their behavior improves, then we can definitely release them from their restraints. And then documentation, documentation, documentation. De-escalation strategies are directed at reducing a client's agitation or aggression. So you may have heard of this terminology before. We need to de-escalate them. This is the first step towards assisting a client towards self-control and maintaining a self and therapeutic milieu. De-escalation should be used to avoid behavioral emergencies and avoid restraints and seclusions. Your facility may have some de-escalation training that you'll have to go through, and I would just highly recommend that. Again, you're going to see mental health wherever you go, and being able to de-escalate a situation is being just proactive in avoiding restraints or seclusion. Other tasks that we can think of when it comes to legality and ethics is forensic nursing. So this type of nursing can support victims or perpetrators of crime and violence. They can help collect evidence, provision of healthcare in prison settings. If we see violence in the psychiatric setting, usually a prosecutor will not bring charges against disoriented, delirious, psychotic, or otherwise mentally impaired patients. However, violent patients, friends of patients, and family members who are aware of their action can be charged with serious crimes. And that concludes Chapter 2 in your ATI book. If you have any questions, you can shoot me an email or we can chat about it in class. Thanks, guys.